Good day, students. So here we are again on our online session, and this is formally the start of our discussion. So this is Criminal Law 1, and we'll be using the revised penal code as well as uh, related special laws. I have mentioned this during the discussion on the course outline. So here we will include the indeterminate sentence law as well as the probation law. So to start with the definition of criminal law, please note that penal laws are those acts of the legislature which prohibit certain acts and establish penalties for their violations. Criminal law is that branch of municipal law or a public law which defines crimes, treats of their nature, and provides for their punishment. It is also that branch of public substantive law in a sense that it defines the state's right to inflict punishment and the liability of the offenders. It is public in a sense that it deals with the relation of the individual with the state because these acts are or these crimes are acts against the state. But take note that there are constitutional limitations on the power of the Congress because I made mention earlier that it is an act of the legislature. But before that, let's try to understand what is actually a crime because that's the root word of criminal law or the word criminal. The root word is crime. In its simplest form, a crime is an act committed or omitted in violation of a public law forbidding or commanding it. So pwedeng ginawa, pwede ring hindi ginawa, no? Omission. But it must be in violation of a public law that either forbids it, halimbawa, binagbabawal. So once you commit it, it makes it a crime. Or commanding it. So yun ang ini-encourage ng batas na yon, pero hindi mo ginawa, you can also be held criminally liable. Okay. So let us also very quickly go through the theories or schools of thought in criminal law. Meron tayong tatlo. We have the classical or juristic theory. We also have the positivist or realistic theory. And then we have the eclectic or mixed theory. Classical because the basis of the principle here in this theory, classical or juristic theory, is that the basis of criminal liability is human free will. This theory believes that man is essentially a moral creature with an absolutely free will to choose between good and evil. While the positivist or realistic theory states that the basis of criminal liability is the sum total of the social and economic phenomena to which the offense is expressed. So, as such, punishment is not the solution, as the criminal is not entirely to be blamed. While eclectic or mixed theory states that it's a combination of the positivist and classical theory, wherein crimes that have economic and social causes should be dealt with a modicum of compassion. Penalties are imposed for both retribution and reformation. So, ang isang tanong din na gusto nating sagutin, no, kasi when we discuss of criminal law, baka yung iba iniisip din, no, are there common law, no, yung kanto-kanto, no, crimes also that exist in our jurisdiction. So, in the Philippines, crimes that are known in the United States and England as common law crimes do not actually exist here in our setting. Our jurisdiction adheres to the principle of nullum crimen nullum pena sine lege, which means that there is no crime unless there's a law punishing it. So kung walang batas, hindi yan nakasaad sa penal law or revised penal code or special laws, then it cannot be punishable. All right? Now later, we will go through the difference or as a deeper discussion on crimes, we will look into the difference between mala insi and mala prohibita. But for now, let us look into the constitutional limitations of the legislature in enacting a criminal law. Remember that the Bill of Rights, as enshrined in the Philippine Constitution, is very, very important in the discussion of the powers of the Congress insofar as their ability to enact a penal law. First is the equal protection. It is stated in Section 1 of Article 3 of the Philippine Constitution that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. So that's one limitation of enacting a penal law. It must be general in application. Hindi siya pwede na i-limit into a particular um, group of people because that can be tantamount to a class legislation also. So halimbawa, if you want to, if say the Congress would enact a law that specifically penalizes lumans, exclusively for lumans or Muslims, because um, the recent issue on security, on terrorism, the accusations on violent extremism, ayan. So, hindi po pwede yun, no? Hindi basta pwedeng magsagawa ng batas na hindi general ang application because it must adhere to the equal protection of laws as sanctioned by the Philippine Constitution. Specifically, no person shall be held to answer for a criminal offense without due process of law. In all criminal prosecutions, the accused must be presumed innocent until the contrary is proved or until uh, guilt is proven beyond reasonable doubt. No person or class of persons shall be deprived of the same protection of the laws which is enjoyed by other persons. No? Kailangan pare-pareho yan, general in application. Um, for the legislature to do a valid classification or to make it a reasonable classification, it must rest on substantial distinctions. No? It must also be germane to the purpose of the law, and it must not be limited to existing conditions only. It must apply equally to all members of the same class. No? Another limitation is that it must observe substantive and procedural due process. So substantive dahil sa kailangan dumaan siya sa um, you know review of the content of the law. Official actions must be responsive to the supremacy of reasons and the dictates of justice. It must satisfy the following: that there must be a court or tribunal clothed with judicial power to hear and determine the matter before it. Ito pagka kailangan i-deliberative. There are such omissions or violations or commission, no, yung nagawa, no, yung mga acts that violates the penal law, either prohibiting it or um, what do you call this, commanding it. Jurisdiction must also be lawfully acquired over by the court over the person of the defendant or over the property which is the subject of the proceeding. Kung wala pang jurisdiction, the case will not prosper. No? Madidismiss yung kaso. The defendant must be given an opportunity to be heard. No? Kailangan marinig natin yung salaysay ng inaakusahan. Hindi pwedeng mag-accuse tayo and wala ng trial because that would be a bill of attainder. No? Mamaya, dadaanan natin. Judgment must be rendered lawful hearing. No? So, in criminal proceedings, due process requires that the accused must be informed why he is being proceeded, no? Bakit siya inaakusahan, ano yung inaakusa sa kanya, and ano yung mga karapatan niya bilang isang akusado. So, kaya importante, no, yung binabasahan ng Miranda rights. And I want you to read on, no, kung ano itong Miranda rights. Legislature should also avoid or should not impose cruel and unusual punishment or excessive fines. It must be reasonable, no? Hindi pwedeng masyadong cruel punishment, no? Halimbawa, ito torture. Hindi po pwede yun, no? May mga provisions tayo sa Revised Penal Code na pinagbabawal yung mga ganong bagay, no? No, and even sa special laws, no, kasi meron tayong anti-torture law. So the certain examples of itong mga excessive, no, or unusual punishment would be yung mga degrading or inhumane penalties or punishments. Yung kaya nga inano din natin, no, yung sa death penalty. Nirepaso yan at ngayon reclusion perpetua, ni-reduce to reclusion perpetua instead of the death penalty. Yung mga physical or psychological or any degrading na punishment dun sa detainee or sa prisoner, halimbawa pinapahubad, yun nga, yung tino-torture, no, or hindi pinapakain, yeah, mga bawal po yun, no. The imposition of a penalty of death is prohibited now, as I have mentioned earlier. Tinanggal na rin yung sa by lethal injection na death penalty. Na-repeal na yon at ang maximum penalty natin ngayon allowed by the law is reclusion perpetua. There's a period given to that, no, yung duration. So,